Episode 132 of the Interpretation Station is called to order. Welcome, ladies and gentlemen. I hope you are all doing well. Let's get straight down to today's episode, okay? I'm going to give you 3 Latin terms, okay? And I'm going to give you 3 English terms. And hopefully by the end of today's episode, you will be able to match the Latin term with the English term. The 3 Latin terms I'm going to give you are jus cogens, that's the first one. Aut dedere or judicare, that's the second one. Forgive my pronunciation if it's perhaps wrong. And the third one is pacta sunt servanda. And the 3 English terms I'm going to give you are binding. The second one is extradite or prosecute. And the third one is a peremptory norm. Well, all this Latin and all these legalistic sounding words can only mean one thing. Yes, today's episode is going to be dedicated to that scariest of bodies. It's called the International Law Commission. And I have done episodes in the past taking statements from the International Law Commission. I will put links up to them. It's very difficult. It's lots of really thick legalese. And if you ever have the misfortune to be assigned to a meeting of the International Law Commission, you got to make sure you really do your homework. This is not the sort of thing you can just be dropped into and assume you're just going to be able to wing it. I think I've probably tried and failed. So, yes. Now, what has spurred me to do this episode? Well, the International Law Commission was actually meeting. I think they've finished their session, their long sort of spring-summer session. They meet twice a year, I believe, both for about 6 weeks at a time. As I said, I think they're done for now. So I've dodged that bullet. I did a few meetings of them actually. It's as I say, it's very challenging. And anyway, during the course of their session in Geneva, I was walking. I don't know if you've ever been to the UN in Geneva. The Palais des Nations. It's a huge, sprawling building. It's a real labyrinth. And down one of the corridors, a real random corridor, to be honest, I found this exhibition had been set up with these boards, 18 of them, telling the story of the International Law Commission. And I just started reading it, and I thought, bloody hell, it's actually very interesting. This exhibition gives a lot of the background to it. And you know what the thing is like with interpreting? I suppose in some ways it's a bit like driving, okay? So you can learn to drive, okay? And you can drive well enough to be able to pass your test and go out on the road and hopefully not kill anyone. But you only really start to become, I think, a very good driver once you actually know, let's say, the inner workings of a car. And once you actually know the inner workings, then you understand more why certain things are going on. You understand why when I drive an old Opel Astra, when you switch the engine on, you hear this sort of noise, this for about 3 seconds, and you sort of know, oh, that's the fuel pump turning on. Just these little things, just these little sounds that you recognize, and you have a slightly, just a bigger understanding of how the car works. And I think it's quite similar with interpretation. Like in a meeting like this, you can, as I say, you can do the International Law Commission. You can survive meetings, having a superficial understanding, just understanding what words work, what the sort of the word solutions are. But things only become that little bit easier and more fathomable once you actually understand what's going on there. Because so much of what is said in the International Law Commission, it really permeates what is said at much more higher levels. You're unlikely yourselves perhaps to end up in the International Law Commission, but the concepts that they discuss there permeate through all aspects of international law. They permeate through things said at the highest level, at the General Assembly level, at the Security Council. And if you know, if you're in the Security Council and you hear one of these expressions, you might just come across this expression and think, what the hell did that come from? But if you know the sort of inner workings of the monster that is called international law, shall we say, you'll be able to say, oh, that comes all the way from down there, and okay, I can understand then why this delegate is quoting it. Things start to make a bit more sense. So you don't necessarily have to work at the International Law Commission, I hope, for this episode to be of some benefit to you, because the way I'm going to be doing, so that exhibition that I ran into, I took photos of all of the placards that were up. Okay, so I'm going to be taking you through them. And what I'm going to be highlighting what I find are the interesting sections for me, these segments that, for example, as I say, permeate into other aspects of work at the UN, for example. And where I can, I'm going to sort of give you sort of concrete examples of some of these concepts in practice, so that you can relate it more, have a more tangible understanding of how these things interrelate, shall we say. So what I'm going to do is I'm going to now share the screen with you, and I'm going to take you through this exhibition. I've highlighted what I consider to be the most interesting bits of vocab, and what I think the easiest way to do it, actually, because it brings into play everything. Lots of stuff to do that comes from the UN Charter, to do with concepts from the main Geneva Conventions, all sorts of things that are cited at the very highest levels, shall we say. And what we'll do is, I think the easiest way is for me just to sort of speed read it through it, give you a rough idea of what's going on, and then I'm going to stop, as I say, at the really the important points, tell you stuff that you should really try and remember, or maybe do a bit more reading up on. You might find interesting. There's other little bits of just general knowledge that I found interesting when reading it, that are worth. You can impress your friends with them over dinner one night. So here we go. So this is the introduction. So they quote the UN Charter. We, the peoples of the United Nations, determined to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. So that's taken from the Charter of the United Nations. By the way, if you're going to have work in any organization vaguely related to the United Nations, I advise you to learn the Charter. Learn the Charter in your own native language, and any language that you're working into. It's going to help you a lot. All right. So, as the preamble of the Charter of the UN proclaims, international law, rules that govern relations between states and increasingly with international organizations and individuals, is central to a just and peaceful world. International legal rules enable international trade, protect our environment, facilitate diplomatic relations, and safeguard human rights. Moreover, they allow states to resolve their disputes peacefully by relying on law instead of force. In national legal systems, laws are typically made by a central lawmaker such as a parliament or Congress. At global level, there's no single body that can legislate for the world. Instead, international law mainly emanates from customary practices and agreements between states. So that's good vocab, I think, just to know words like, again, this is looking purely just from an interpreting point of view, emanates from, derives from, arises from. These are the sort of synonyms that you will hear for that. For centuries, most of international law remained in unwritten form. This was still the case when the UN was founded in 1945. To help clarify, order, and formulate, to codify and progressively develop the most fundamental rules of international law, the UN established the International Law Commission in 1947. Again, I like this wording that I've highlighted in red, to clarify, order, and formulate the fundamental rules of international law. Now, in particular, to codify and progressively develop. So this is what the International Law Commission is all about. Okay, the codification and progressive development of international law. So they're going to come back to this repeat several times during this exhibition, and there's going to be an explanation of what the difference is between the two of them, between codification and the progressive development. So just make a mental note of that expression in particular. In the past 7 decades, the ILC, as it is known, has played an indispensable role in the progressive development of international law and its codification. What did I tell you? See, there it is again. This exhibition examines past, present efforts to progressively develop and codify international law. Again, it's been prepared by the Codification Division of the UN Office of Legal Affairs to mark the 70th anniversary of the first session of the ILC in 1949. The ideal to ground international relations in a clear, stable international legal order goes back at least 2 centuries, continues to inspire individual states and international organizations until today. Okay, let's move on to page 2. Now, I'm not going to go into the descriptions of the pictures. You can look up the pictures yourself. Some of them are quite interesting. So this is about the early codification movement, gives you some of the history. Individual efforts to be without a code is to be without justice, wrote the English jurist and philosopher Jeremy Bentham in the late 18th century. He's a big name in the original, in what we consider, modern international law. At that time, international law consisted mainly of moral principles and diplomatic custom rather than written rules. Striving to clarify the law and fill legal gaps, several individuals made first attempts to write down, to codify international legal rules. So, okay, that's what basically codifying is, writing down the rules, or putting them down on paper. For example, in 1863, the German-American jurist Francis Lieber drafted instructions on the laws of war for the United States Army at the request of U.S. President Lincoln. A year later, in 1864, the First Geneva Convention on the Law of Warfare was concluded, spurred on by Henry Dunant's International Committee for the Relief of the Wounded, now known as International Committee of the Red Cross. Now, this is interesting. So this is where the first Geneva Conventions sort of spring from, okay? Everyone talks about, the Geneva Conventions to do with wars and things, prisoners of war. So this is where they sprang from, this convention of 1864. And this is a name you should know, okay? Henri Dunant, okay? He's the founder of what is today known as the International Committee of the Red Cross, the ICRC. And of course, there's also the International Committee of the Red Crescent. That's for the Islamic countries. Around the fin de siècle, activists like first Nobel Peace Prize laureate Austrian Bertha von Suttner vocally promoted a codification of peace. Some scholars proposed their own codes of international law, such as Swiss-German Johann Caspar Bluntschli, and I'm not going to read out that name of his book, and the Italian Pasquale Fiori. I'll try this, I can sort of do a bit of Italian. Il diritto internazionale codificato e la sua sanzione giuridica. Okay. Alabama. Central aim of the early codifiers was to encourage the peaceful settlement of disputes. Very important concept, okay? Also, you could say peaceful resolution of disputes you'll often hear talked about as well. And this in particular, I want to refer you here in the Charter to Chapter 6 of the UN Charter. Okay, so here is the Charter. We're in Chapter 6, Pacific Settlement of Disputes. Actually, I've mentioned this before, so it's interesting. The original wording when the chart was written, they used the word Pacific. So if you really want to impress an examiner, if you're sitting a UN exam, and they talk about this subject, and if you say Pacific Settlement of Disputes, they will know, oh my God, he really knows, this guy really knows his charter. More typically, though, you'll hear now, it's peaceful settlement of disputes, peaceful resolution of disputes, and there it is. You see, Article 38. Without prejudice, the provisions of Articles 33 to 37, the Security Council may, if all the parties to any dispute so request, make recommendations to the parties with a view to a pacific settlement of the dispute. So this ideal gained momentum when in 1872 an arbitration commission in Geneva rendered the first significant arbitral award in a dispute between states, the Alabama affair. By the way, again, just to implies vocab, render an award. Okay, these collocations I find always very useful, particularly if you're a non-native English speaker, if you're, say, an English B. I often talk about handing down an award, for example, handing down a verdict, but you can render one as well. The Arbitration Commission ordered Britain to compensate the US for damage done during the American Civil War by Confederate warships, which, in violation of the laws of neutrality, had been built in British ports. The Alabama Award proved the potential of the peaceful dispute settlement based on international law. It underlined the need for clearly formulated written rules that would make the outcome of proceedings more predictable and fair. Okay, number 3, a movement gathering steam. Organized engagement. Encouraged by the success of the Alabama Arbitration, international law has founded 2 associations in 1873, the Institut de droit international and the Association for the Reform and Codification of the Law of Nations. Both continue, now known as International Law Association. I think you come across that occasionally. Both continue to promote the progress of international law in their own way. The Institute draws on the legal expertise of its selective membership to advance the juridical conscience of the civilized world. Okay, I thought that was quite strange word, the juridical conscience, because often you hear in French, when they talk about something juridique, okay, in French, I know it's completely normal to say juridique. Usually when I hear that in French, I'll render it as legal. But there you go, they talk about the juridical conscience. Never mind. The ILA opened its membership to all in furtherance of international understanding and respect for international law. I just thought that word here, the furtherance, the advancement, the promotion, okay. Very high register furtherance. Since their foundation, both bodies have made significant contributions to the development of international law. Academic institutions also joined the codification movement, most prominently the Harvard Research in International Law, led by Professor Manly Hudson, produced various draft conventions and studies that are still quoted today. 1949, Hudson was elected the first chairman of the International Law Commission. There you go. Manly Hudson was the first chairman. Conference for Peace for the second half of the 19th century. States took on increasing interest in the codification project. At the time, codification was considered as important to world peace as disarmament and free trade. Early conferences focused on technical matters, for example, postal communication weights and measures, rather than development of international law as a legal system. More concerted codification efforts were undertaken at the regional level, particularly by the Pan-American Union. This bit's interesting, I find. Building on these initiatives, in 1899, Tsar Nicholas II of Russia convened a unique peace conference in The Hague, the Netherlands, not in response to a specific war, but to lay the foundations of a real and lasting peace. The resulting Hague Conventions, or Hague Law, regulating the conduct of armies during hostilities, largely remain in force. So there you go. That's the Hague Conventions, and it's useful to know what the Hague Conventions are, and I will just use the resources provided me by Wikipedia. Thank you, Wikipedia. The Hague Conventions of 1899-97, a series of international treaties and declarations negotiated at 2 international peace conferences at The Hague in the Netherlands. Together with the Geneva Conventions, the Hague Conventions were among the first formal statements of the laws of war and war crimes in the body of secular international law. The third conference was planned for 1914, later rescheduled for 1915, but didn't take place before the start of World War I. So there you go. So Geneva Conventions are perhaps the better known ones when it comes to war, but then you have these 2 important Hague Conventions as well of 1899 and 1907. Moving on. To promote the peaceful settlement of disputes, the Hague Peace Conferences also established the Permanent Court of Arbitration. The Peace Palace in The Hague, originally built for the Permanent Court of Arbitration, now also houses the International Court of Justice, the principal judicial organ of the United Nations. To mark the centennial anniversary of the first Hague Peace Conference, the UN General Assembly declared the period 1990 to 1999 the UN Decade of International Law. So this is again an interesting bit of general knowledge. The ICJ, International Court of Justice, originally known as the Permanent Court of Arbitration, and yes, they still to this day, that building is known as the Peace Palace in The Hague. So that's useful knowledge. So then, Panel 4, Codification and the League of Nations, okay, the Société des Nations, okay, the predecessor, remember, to the United Nations. The role of the League of Nations. After the First World War, codification effort was taken up by the League of Nations. The League continued to promote technical cooperation through treaties, for example, in transportation and commerce, and through the International Labour Organization, addressed various social issues. In 1922, it established the Permanent Court of International Justice, the predecessor of the International Court of Justice, to settle disputes between its members peacefully. To provide a legislative basis for the court, the League appointed 17 legal experts to the Committee for the Progressive Codification of International Law. In 1924, the committee representing the main forms of civilization and the principal legal systems of the world was tasked with identifying legal topics ripe for codification. Of the 9 topics proposed, the League's Assembly selected 3: nationality, territorial waters, and state responsibility, for a codification conference that was to be held in The Hague in 1930. And certainly these, I just highlighted that, this idea, certainly state responsibility, territorial waters, they're still very much topics that are at the forefront of the Commission's work today. If you ever have the grave misfortune ever to be assigned to a meeting, maybe you do freelancers get assigned to the ILC? I'm just thinking, if you think, oh great, I'm going to UN to work, and you get assigned to the ILC, you might, it's not impossible. The 1930 Hague Codification Conference. The 1930 Hague Codification Conference proved overly ambitious. Delegates found they had too little time to cover the many complex issues on the agenda. Neither the Codification Committee nor the Conference Preparatory Committee had prepared draft conventions as a basis for negotiations. Consisting of independent experts rather than government officials, these bodies had focused on technical legal matters and had left delicate political questions to the conference. As it turned out, the codification involved more than mechanically transcribing customary law into written agreements. It also required the progressive development of new rules to fill gaps and resolve conflicts, a political as much as a legal exercise. That's an important expression, by the way, in this field. Customary law. I know in Spanish it's ley consuetudinaria. Okay, if you ever hear that, it's customary law. That's a kind of phrase that might permeate into other fora, other meetings. In the end, the conference produced few notable results. It made some progress in the fields of nationality and territorial waters, but failed to reach an agreement on state responsibility. However, it made general recommendations to improve the codification process, which the Assembly of the League of Nations revised and adopted in 1931. Many of these lessons informed the drafting in 1947 of the Statute of the ILC. Moving on then, number 5. Okay, so something happened when I was scanning these documents. They didn't quite come out properly. The title bit was left out on some of them, so I've put it in there. This is the name of this. The title of this was the Charter and the Statute. Article 30 of the UN Charter: the General Assembly shall initiate studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. There it is again, one of our if there's one phrase you take away from this episode, let it be that, okay? That idea, the progressive development of international law and its codification. And you'll find out what the difference between the two is in a minute. San Francisco, following the devastation of the Second World War, the 50 states negotiating the UN Charter in San Francisco in 1945 were anxious to revitalize and strengthen international law. By the way, so you know the UN Charter was signed in San Francisco, right? If you hear talk about the spirit of San Francisco, that all harks back to that, the signing of the Charter in San Francisco. A proposal to empower the General Assembly to impose binding international rules upon its members was quickly rejected. Instead, Article 13, Para 1A of the Charter instructs the General Assembly to initiate studies, make recommendations for the purpose of encouraging the progressive development of international law and its codification, to make more precise recommendations on how to discharge this mandate. That's a good expression, okay, by the way. That's a good collocation, to discharge a mandate. I use it a lot. The first session of the GA established a committee on the progressive development of international law and its codification, consisting of 17 government representatives. This committee of 17 recommended the creation of an international law commission. Acting on this recommendation, the General Assembly approved the statute of the International Law Commission by Resolution 174, Roman II, on 21st November 1947. That's how those resolutions, but the General Assembly resolutions, that's their format, okay? There's a regular Arabic number, if you like, followed by a Roman number, and you would read that as Resolution 174, Roman 2. The Statute of the ILC, the Committee of 17 considered many of the lessons from the 1930 Hague Codification Conference, which are reflected in the Statute of the International Law Commission, as a permanent subsidiary organ of the General Assembly. Okay, that's an important thing to know, right? Its status. The Commission is not subject to time constraints associated with diplomatic conferences. Now, just so that you know what a subsidiary organ of the General Assembly is, it's useful to to put it into perspective. What exactly is a subsidiary organ? To give it some context, okay, so here we have on the UN page subsidiary organs of the General Assembly. So you have the United Nations Environment Assembly is an example. The Human Rights Council, okay, that is a subsidiary organ of the General Assembly. That's perhaps the most important one. The Executive Board of Unicef is a subsidiary organ, as is of the Executive Board of the World Food Programme. And here it just gives you a bit of an outline. What is a subsidiary organ? Divided into 3 intercategories: boards, commissions, committees, councils, and panels, working groups, and others. After discussing items on the agenda, seeking where possible to harmonise the various approaches of states, the subsidiary organs present their recommendations, usually in the form of draft resolutions and decisions, to a plenary meeting of the Assembly for its consideration. And then that is where you'll have the votes taking place, right, in the General Assembly. Usually have the votes that will all take place in, like, at the end of the session of the General Assembly, a general debate. So in like November, I think, lots of votes and different resolutions. Let's get back then. Okay. It is tasked with preparing draft instruments that reflect existing law and that propose new rules. Members serve as independent legal experts, but the Commission consults with governments throughout the drafting process. So, okay, you'll see in the members of the Commission, they're independent. The idea is that they're independent experts. They don't directly represent the country that they're from. It also submits the outcome of its work to the General Assembly, a political body. Although the Committee of 17 had recommended convening the Commission full-time, it meets for 10 to 12 weeks a year. By way of compensation, it was suggested that the Commission Secretariat shouldn't merely offer administrative services, but act as a centre of scientific research. The Codification Division of the UN Office of Legal Affairs fulfills this role. Now, this is a very important paragraph here. Codification versus progressive development. It's important because it explains to you what the difference of the two concepts is. Pursuant to Article 13, paragraph 1A of the Charter of the UN, the statute sets out different procedures for the progressive development and for the codification of international law. The Committee of 17 already questioned the separation of working methods in 1947, noting that no clear-cut distinction between the formulation of the law as it is and the law as it ought to be could be rigidly maintained in practice. 70 years of Commission practice has confirmed that intuition, yet the distinction remains meaningful. Codification entails the precise formulation and systematization of existing rules of international law, rules that are already binding on states. Okay, so codification basically tackles what already is in place, what already exists. However, progressive development involves the formulation of new rules, ex ferenda, which can only bind states upon their explicit consent. A lack of differentiation between the two risks either understating or overestimating existing legal obligations of states. So that's basically what that difference is. That's a very important idea. The codification versus progressive development. It's stuff that's already exists versus stuff that may come along in the future. At least when I found out that was the difference, that sort of cleared a lot of things up for me, at least in terms of my understanding. Okay, number 6, into the International Law Commission. Topics at its first session in Lake Success, New York, 1949. The Commission surveyed the entire field of international law to set topics for codification. Most of the topics included in its initial work program in 1949 have been successfully taken up and completed by the Commission. The Commission continues to monitor developments in international law for possible new projects. It also considers topics referred to it by the GA and the other organs of the UN. Membership. Pursuant to the state, members shall be persons of recognized competence in international law who as a group should represent the main forms of civilization and of the principal legal systems of the world. So, they want to bring in, the idea is to have them represent, to have a sort of fair reflection of all the different branches or the different schools of law, I guess, around the world. Everything from, the Western system, the Islamic system of law, presumably, all the different schools of law around the world. No two members may be nationals of the same state, and seats are proportionally distributed among regional groups. The GA elected the Commission's first 15 members in 1948. Since then, membership has been enlarged 3 times to 21, 25, and the present 34. Members serve for a period of 5 years and are eligible for re-election. Women continue to be underrepresented, currently making up only 4 out of the 34 members. There you go. So this is probably the time where I should play that song. What is it? It's a man's world. Well, there you go. It applies to the International Law Commission. What do you do? The Commission meets annually for 5 to 6 week sessions at its seat in the Palais des Nations in Geneva. Is presided by a chairperson and 2 vice chairpersons. It has occasionally met elsewhere, including in New York. The Commission's substantive work is spearheaded by special rapporteurs who lead the Commission's research on a specific topic, propose texts for adoption, and draft-related commentaries. Okay. The Commission debates the reports of its special rapporteurs in plenary and refines texts in the drafting committee till they're ready for adoption. It sends all draft instruments for comments and observations to governments and possibly other institutions. That's on the first reading. After considering replies, the Commission submits to the General Assembly a final text with commentaries, second reading, together with a recommendation for further action. But really, I would put this in red, just this idea of the commentaries. I think it's important to understand, because when I first did a meeting of this, I didn't really quite understand what they were talking about when they were talking about the commentaries. But when you have any treaty or convention, it contains a commentary. Okay, it basically to explain. To give a more simple explanation of some of the concepts contained in the treaty or convention, can also describe to you the differences that existed between the various members of the committee. And that all goes into the commentary. Basically, if they can't decide on putting something specific into the treaty itself or the text, it goes into the commentary, okay? And it's just important to know what they mean when they say, we'll put that in the commentary. That's what we call English. Like in Spanish, they'll call in los comentarios. But you wouldn't say in the comments. You say it goes into the commentary. Outcomes. The statute mandates the Commission to either prepare draft conventions or publish reports. In practice, the Commission's outcomes can take various forms, from draft articles and principles to guidelines and conclusions. Again, so it's just important to know these instruments, okay? They will often talk about they're doing the draft articles. They're always changing draft articles, talking about guidelines, okay? These have served as the basis of 16 conventions and 6 optional protocols adopted by a diplomatic conference or the General Assembly. Beyond formal conventions, the work of the Commission is widely regarded as authoritative and is frequently relied on by governments, international organizations, national and international courts and tribunals. In this way, the Commission has laid and continues to strengthen the foundations of the modern international legal order. Fundamental rights and duties of states. Article 2, para 4 of the Charter of the UN. All members shall refrain in their international relations from the threat or the use of force, I should have underlined this and highlight this, against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. I'm also going to highlight the word inconsistent with, because it's just from an interpreter's point of view, it's easier to say that does not comply with, okay? Something being consistent with a purpose or with a treaty is an expression that I'll use quite a lot, consistent with agreement. And obviously, if it's not consistent, then it's inconsistent. On January the 1st, 1942, 26 nations united to fight the Axis powers in the Second World War. 3 years later, in the face of imminent victory, the signatories of the 1942 declaration by the United Nations met in San Francisco for the UN Conference on International Organization. That's interesting. That's what it was called. That was what the name of that big conference was called when they decided to create the United Nations. On the last day of the Conference, 26th of June 1945, they signed the Charter of the United Nations. The Charter is itself an ambitious exercise in the progressive development of international law. It's the first ever international instrument to combine a general prohibition on the threat or the use of force, Article 2, Paragraph 4, with a collective security system to enforce it. Okay, so that's just again useful vocabulary. What is the Charter? Well, there you go. What does it do? It has a general prohibition on the threat or the use of force, especially that's an expression that gets used all the time. The Charter prohibits the threat or the use of force. Just remember that as a package. And to enforce, with laws. It's a good verb to remember, to enforce, to ensure enforcement, to make sure that signatories do what they signed up to. The Charter recognizes only two exceptions to the threat or use of force: authorization by the Security Council, Article 42, and individual or collective self-defense, Article 51. Now, this is very important, especially in the current context. So let's just look at Article 42 first of all, okay? Again, just to give you some context. Okay, so this is just taken from a site that I found. So it's interesting. Before 1991, the only case in which large-scale military operations followed a decision of the Security Council didn't fall under Article 42. So this is talking about the Korean War back in the 1950s, and they invoked Article 51. But then we see it's interesting that later, since 1990, however, the Security Council has made use of Article 42 in a significant number of cases. Most prominent was the authorization of member states to repel the Iraqi invasion of Kuwait, so Gulf War #1, which followed an early decision to enforce economic sanctions against Iraq by naval blockade. Then we see, 1992, military action in support of the peacekeeping force in Somalia, conferred enforcement powers. And so, as already mentioned, only towards the end of the 1990s, the Security Council again came to authorize larger operations on the basis of Article 42. So Sierra Leone, the ECOWAS intervention, the Economic Community of Western African States. It's a useful acronym to know, by the way, ECOWAS. They are a player. And then, peacekeeping operation same year to Kosovo. In the former Yugoslavia, was dispatched there invoking Article 42. Now, Article 51, what's the significance of Article 51? Collective self-defense. Well, the current conflict in Ukraine, that's what the Russians invoked. That's what that's their grounds for intervening there in Ukraine. They went and invoking Article 51 of the Charter, which reads, Article 51 reads, nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken the measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense, important words for us to interpret, the exercise of the right of self-defense, shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility of the Security Council under the present Charter to take at any time such action as it deems necessary in order to maintain or restore international peace and security. So apparently Putin did invoke Article 51 in a speech broadcast, I think just a couple of days, maybe the day before the invasion at 4 a.m. He invoked the United Nations Charter, the article on self-defense. So as you can see, this is very much related to existing events. Anyway, let's get back to this then. So, a standing United Nations army foreseen in Article 45 of the Charter never materialized. Instead, Article 41 permits the Council to impose sanctions on states, organizations, and individuals that pose a threat to international peace and security, including when they fail in their responsibility to protect civilian populations. As a last resort, the Security Council may authorize states to use all necessary means to respond to a threat. I think this sort of talks, this responsibility to protect civilian populations. This was a concept that was bandied about quite a bit a few years ago. I've heard less of it more recently, but basically to justify, I think they use it to justify the invasion of Yugoslavia, Iraq, the R2P, the idea of responsibility to protect civilians. So again, you don't hear about as much as you used to, because I think it's because it was felt that it was only the West that could decide which civilian populations needed protecting, and I think the Russians, the Chinese, were saying, "Hang on, what about if we have civilian protections that we deem need protected, but who perhaps the West doesn't feel merit that same protection?" So it's a very controversial concept anyway. The General Assembly reaffirmed the core principles of the Charter in its Declaration and Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations. Built on the work of the ILC in relation to the fundamental rights and duties of states, the Commission's first substantive agenda item in 1949, the Declaration, which continues to reflect the core values of the international legal order, re-emphasizes the principles in the non-use of force, peaceful settlement of disputes, non-intervention in the domestic jurisdiction of any state, sovereign equality, equal rights and self-determination, and the duty to cooperate and fulfill in good faith the obligations assumed under the Charter. This is very important vocabulary, okay? That's the reason why I highlighted. All these concepts get invoked all the time in the Security Council, General Assembly. Obviously, usually it's like non-intervention in the domestic affairs and the internal affairs of any state is a sort of slight different wording, but anyway, those are all crucial concepts to be familiar with. Okay, international criminal justice. At the end of the Second World War, the victorious Allied powers took the unprecedented step of prosecuting the defeated Axis leadership, not for domestic crimes, but for crimes under international law. Yet, while the Nuremberg and Tokyo tribunals convicted many of the accused, international criminal law remained in its infancy. The General Assembly considered its development so urgent that it tasked the Commission in 1947, even before its first members had been elected, with the formulation of the Nuremberg Principles and the preparation of a draft code of offences against the peace and security of mankind. Okay, so Nuremberg is obviously where you had all the trials of the Nazis, and you had the Nuremberg Code, which still exists and is often cited as a body of as a legal text, but it's useful again to be familiar with. The Commission completed the former in 1950, enumerating a set of principles that remain at the heart of international criminal law today. Individuals can be held responsible for crimes under international law. High-ranking office, including the head of state or government, does not absolve offenders from international criminal responsibility. Perpetrators cannot behind superior order defences. It was an order. The Commission reflected these principles in its 1954 draft Code of Offences. Again, some important vocabulary here, important concepts, the idea, of heads of state being subject to prosecution for war crimes, and the fact that their position does not absolve them. That's a good word in English, right? To absolve you from a crime, absolve you from prosecution, absolve you from punishment. Perpetrators can't hide behind superior order defences. It was an order. So this is an important thing that comes up a lot in certain UN treaty bodies like the Committee of Torture. It basically means that the lower ranking soldiers or whatever, police officer, can't just, it's not simply enough for him to say, look, my superior officer told me to do it, ordered me to do it, I had no option. That does not constitute a sufficient defense. And I think this was the Nuremberg defense it was known as, because a lot of the Nazis at Nuremberg basically invoked that excuse, saying, "Oh, we couldn't do anything about it. The boss told us to do it, so we had to." And I believe the German for that is Befehl ist Befehl. So that's that is a very important idea to be superior orders. The idea of chain of command, superior orders, that gets quoted a lot, as I say, in a lot of these committees, treaty bodies. However, disagreement with the Commission and the General Assembly on the question of defining aggression stalled the project. It took the GA another 20 years, 4 different special committees to define aggression in Resolution 3314, Roman 39 of 14 December 1974. The Commission only took up work on a draft code of crimes against the peace and security of mankind and a statute of International Criminal Court again in 1982 and 1990 respectively. This time it succeeded. On 15th of June 1998, the United Nations Diplomatic Conference of Plenipotentiaries on the Establishment of an International Criminal Court, the ICC, opened in Rome to consider the Commission's proposed draft statute for an International Criminal Court. So 1994, a month later, the conference adopted the Rome Statute of the International Criminal Court. So these are very important things to note. The Rome Statute is what governs the way that the ICC works, and the ICC itself, okay, the International Criminal Court, which is based in The Hague. And I think the tribunals, against the war crimes in the former Yugoslavia, in Rwanda, operated under the auspices of the International Criminal Court. And of course, the problem with the International Criminal Court with the statute is a lot of the big countries haven't actually subscribed to it. I know the US is not a signatory to the International Criminal Court. I think it's because if they were, then the generals who ordered various operations that were conducted in Iraq during the various Gulf Wars would then be subject technically to prosecution, and the Americans don't want that. The ICC, which has jurisdiction over the crime of genocide, crimes against humanity, and war crimes, opened its doors in The Hague, the Netherlands, in 2002. In December 2017, the Assembly of State Parties decided to activate the court's jurisdiction over the crime of aggression, relying on the definition agreed by the General Assembly in 1974. In addition to these efforts, the Commission adopted a report on the obligation to extradite or prosecute out dedere aut judicare in 2014. Okay, so there you have the answer to the first question I asked at the start of the show. Aut dedere aut judicare, extradite or prosecute. It's currently preparing a draft convention on crimes against humanity to complement treaties on other crimes under international law, including genocide and war crimes. So yes, aut dedere aut judicare. This has come up in statements at the Security Council, Human Rights Council. This is a concept that permeates, my favorite word of the day, does permeate itself to a higher level. Example of aut dedere aut judicare, I did a little bit of reading up on it, was the case with the Lockerbie bombers. Okay, the bombings in Lockerbie, I think in 1988, that were carried out. It was a Pan Am flight, and the plane went down over the Scottish town of Lockerbie. In fact, here is the, again, using Wikipedia here, the principle of aut dedere aut judicare refers to the legal obligation of states under public international law to prosecute persons who commit serious international crimes when no other state has requested extradition. However, the Lockerbie case demonstrated that the requirement to extradite or prosecute is not a rule of customary law. Yeah, I seem to remember that Gaddafi didn't want to hand over the 2 suspected terrorists in the case. Megrahi, was that the name of one of them? To the UK for trial, and I think in the end, I seem to recall that a compromise was reached where the trial was held in the Netherlands under Scottish law. But that's the most, perhaps, the sort of landmark case when it comes to that principle, to that concept of extradite or prosecute. So you can say either, if you hear it in a meeting, you can either say the Latin aut dedere aut judicare, or you can say the English extradite or prosecute. And actually, the times I've heard it referred to outside of the ILC, I know it was in Russian, they tend to refer to it quite a bit. I think maybe it was to do with a meeting in the Security Council once, to do with the work of the ICTY, the one on the criminal court on Yugoslavia, and they referred, in Russian, it's Liebe Vidi, Liebe Sudi. And so, as I say, you can translate that, you can render that either the Latin way or the English way. Okay, moving on. Law of the sea. This is an interesting topic. International law is sometimes said to be born from the sea. As early as 1609, the Dutch lawyer and oft-proclaimed father of international law, Hugo Grotius, made a plea for the mare liberum, freedom of the seas. For centuries before and after, states' claims over and conduct on the seas and oceans have been a major source of international friction, spurring the development of legal rules and practices. Yet upon the foundation of the UN in 1945, no comprehensive convention regulating the seas and oceans existed. The International Law Commission thus took up the topic of the law of the sea as a matter of priority at its first session in 1949. So you got a lot of law of the sea meetings in New York. That's where they chiefly meet. So that can get very tricky. Lots of the names of different kinds of seafaring vessels and fish, knowing your yellowfin tuna from your bluefin tuna. Ooh, it gets tricky. On the basis of the Commission's proposal, the General Assembly convened the first UN conference on the law of the sea in Geneva in 1958. One of the main challenges of the Commission and subsequently the conference was balancing the desire of states to control their coastal waters, so-called territorial sea, with the interest of others to enjoy the freedom of the seas. Claims the territorial sea varied widely from the maximum distance a cannonball could fly up to 200 nautical miles. While the 1958 conference eventually adopted 4 conventions, it left unanswered critical questions over the breadth of the territorial sea and the limits of fisheries. A second conference, convened in 1960, again failed to resolve the outstanding issues. It took a third conference held from 1973 to 1982 to conclude the United Nations Convention on the Law of the Sea, UNCLOS, consisting of 320 articles and 9 annexes. UNCLOS resolved the controversy over the various maritime zones and introduced a new one, the Exclusive Economic Zone. So it's important to know this is the big convention, okay, that it's UNCLOS, okay, that you'll hear that acronym. And I know the Russians, for example, often refer to it as the 1982 convention. That is the Bible, okay, when it comes to all things sea-related, if you like. And the big deal is really sovereignty of a state over the waters that surround it. And first, and then, so they talk about this exclusive economic zone, and this is quite a useful little diagram that gives it sort of explanation. And again, I'm going to cheat here by using the Wikipedia explanation of an EEZ, or an EEZ for you Americans, perhaps. As prescribed by the 1982 UNCLOS, is an area of the sea in which a sovereign state has special rights regarding the exploration and use of marine resources, including energy production from water and wind. It stretches from the outer limit of the territorial sea, 12 nautical miles from the baseline, out to 200 nautical miles from the coast of the state in question. It is also referred to as a maritime continental margin, and in colloquial usage may include the continental shelf. And it gives you a useful little picture there. Oh, so this is where it gets quite, well, it sounds simple enough. Okay, you get 200 miles, basically, which is yours to do with what you please. But the problem comes when you actually try and define what constitutes the point at which the land of a country's land ends and where the sea starts, because it's not just, the land doesn't just stop at that bit of the beach where the water laps up on the shore. There's a specific calculation for calculating the baseline, where you start counting those 200 miles. And well, that's why there's always plenty of work going on at the law of the sea, and it's going to become an ever more important. Its importance is only going to rise. I think especially with all these the oil. I think is out in the Arctic, and you can see the potential for lots of disputes between the various maritime powers over who has sovereignty over those zones where those oil fields are located. So it's again, this is a very useful thing to be familiar with. And then it says here, interestingly, the difference between the territorial sea and the EEZ is that the first confers full sovereignty over the waters, so the territorial sea, whereas the second, the EEZ, is merely a sovereign right, which refers to the coastal state's rights below the surface of the sea. The surface waters, as can be seen in the map, are international waters. So just be familiar with. It's good to know. Yeah, it's good to know those distances. 200 miles from the baseline. In addition, UNCLOS includes clauses on inter alia, the rights of landlocked states. It's an important concept to know, of course. There's Estado sin litoral in Spanish. The protection of and preservation of the marine environment and marine scientific research. It also contains extensive dispute settlement clauses and establishes the International Tribunal on the Law of the Sea, ITLOS, as it's known, which has its seat in Hamburg, Germany. Combining a wide-ranging scope with detailed provisions, UNCLOS is often considered as a constitution for the oceans. Yes, I've heard that expression used in meetings. The law of the sea continues to develop in light of new challenges such as sea level rise, ocean acidification, overexploitation of natural resources, and piracy. Currently, efforts are underway at the UN to develop an internationally legally binding instrument under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. That's an important concept. That you see, when I was working in New York, I was doing many more of these meetings on law of the sea, continental shelf, and that's something that was talked about a lot. Areas beyond national jurisdiction, ABNJs, they're actually called, and I think there was MBD was marine biological diversity, an acronym MBD and ABNJs. State responsibility. In the afternoon of 22nd October 1946, the British warships Saumarez and Volage struck mines in the Corfu Channel off the coast of Albania. The incident heavily damaged the ships, causing the deaths of 44 sailors. It became the subject of the first contentious case of the ICJ, where Britain claimed that Albania bore international responsibility for the damage. At the time, the rules of international responsibility remained opaque. The field had long been considered a component of other areas of international law, such as law of treaties or the law relating to the protection of foreigners. Over the course of its work on the topic, which commenced in 1955, the ILC established state responsibility as a distinct field of international law, resulting in the adoption of the Articles on the Responsibility of States for Internationally Wrongful Acts. I just thought that was an interesting bit of vocabulary. Internationally wrongful acts in 2001. The articles codify the general principle that every breach of an international obligation entails the duty to make reparation. Okay, reparation. Okay, just generally when we work, I have these. This is an important concept, particularly when it comes to law, to be familiar with, and it's also good to have the synonyms. And I always have a package of 4: reparation, remedy, redress, restitution, which more or less all come, it's all about compensation, essentially. They also contain rules on the attribution of conduct, on justifications and excuses, and on the consequences of serious breaches of peremptory norms of general international law, jus cogens. Now, I'm surprised, actually, it takes this long for them to mention this concept. This is a very important Okay, remember, I think I mentioned this at the start. Jus cogens, peremptory norms of general international law. And here's Wikipedia again. A peremptory norm, also called jus cogens, Latin for compelling law, is a fundamental principle of international law that is accepted by the international community of states as a norm from which no derogation is permitted. Okay, very important concept. They always talk about, in the ILC, always talk, this is a peremptory norm, jus cogens. They always say it as the full package. And then it gives an example of some of these ideas. So that, genocide, the norm banning genocide is just considered to be, there's no derogation from it. There are no exceptions. You cannot commit basically genocide or slavery these other concepts, wars of aggression, torture. There's no excuse. The idea is that there's no excuse for committing such a crime. Okay, and that is a peremptory norm. And it's useful to know. I mean, in Spanish and French. So in Spanish, it's una norma imperativa. In French, a norme impérative. I don't know why. In English, they go for the adjective peremptory, but that's what we do. So anyway, just recognize that. Okay, if you ever hear norme imperative, norma imperativa, that's a peremptory norm, jus cogens. Moreover, the Articles foresee collective responses to violations of obligations owed to a group of states or to the international community as a whole. Obligations erga omnes. Okay, and then here's an explanation of what that means. Erga omnes, Latin phrase that means towards all or towards everyone. Erga omnes, rights or obligations are owed towards all. A property right is an erga omnes entitlement and therefore enforceable against anyone infringing that right. Okay, so that's what if you hear erga omnes. The GA took note of the articles in Resolution 5683 of 12 December 2001, but they've not been converted into a convention. Nevertheless, states often invoke the articles. Just notice the English, to invoke an article in their legal pleadings, and they are regularly cited by national and international courts and tribunals. The Commission's work on state responsibility has resulted in a number of related instruments, such as the Articles on Prevention of Transboundary Harm from Hazardous Activities, the principles on the allocation of loss in the case of transboundary harm arising out of hazardous activities, and the Articles on Diplomatic Protection. In 2011, the Commission adopted the Articles on the Responsibility of International Organizations, which confirm that international organizations, not only states, can be held responsible for violations of international law. Okay, the law of treaties. This is a very important idea when it comes to the International Law Commission. One of the earliest surviving treaties records a peace between the rulers of the Egyptian and Hittite empires, concluded in 1258 BC in modern-day Syria. I had actually heard of that. I'm quite pleased that to be able to say that. And I believe this picture here, the Hittite version of the Treaty of Kadesh, I believe that is what it was called. That's the first form of peace treaty in history that we know of. Just a bit of general knowledge to impress your friends with. Today, treaties govern a wide array of areas of international relations, so human rights to environmental law, trade, and disarmament, regardless of their designation, whether they're conventions, pacts, covenants. Treaties are written agreements between two or more states which create rights and obligations for those states under international law. Together with unwritten customary international law, they are one of the main sources of international legal obligations. Again, remember, consuetudinaria for customary law. In French, it's just loi coutumier. In 1968, a diplomatic conference convened in Vienna to negotiate a treaty on treaties based on the work of the International Law Commission over nearly 2 decades. 1 year later, in 1969, the conference adopted the Vienna Convention on the Law of Treaties, the VCLT, which has become a cornerstone of modern international law. So I think I sort of sarcastically remarked about this convention in that episode that I did. So yeah, it's basically a rule book on rules, but it's a very important text, shall we say, that governs, that really underpins so many of the things that you see in international law. The Vienna Convention codifies some of the central tenets of the law of treaties, which up to then existed merely as customary international law. It provides that treaties are binding. Okay, pacta sunt servanda. So there you go. That was the last, I think the third. A little bit of Latin from the start of the episode. Pacta sunt servanda means binding, but only when states consent to them, i.e. upon their explicit approval. Pacta tertis nec nocent nec prosunt. I've not heard that really used much. It further determines how states can express such consent, provides rules on the creation and modification of treaties, their termination, and how treaties are to be interpreted. The 1969 Vienna Convention also deals with complex issues such as the question of reservations to treaties. This is very important, okay, that of reservations. In 2011, the Commission produced a separate guide to practice on reservations to treaties, which considers to what extent states can opt out of specific treaty provisions, i.e. make reservations while remaining a party to the treaty. So yeah, these are basically opt-out clauses. A state can sign up to a treaty, but it can say, okay, but we'll sign up to it provided that Article 11 doesn't apply to us. That's a reservation. And they talk about, withdrawing reservations, lifting reservations if the state wants to fully commit to it. But it's an important idea that knowing about reservations. And it's actually one of the biggest culprits when it comes to invoking reservations to treaties. It's the US. Interesting example they give here. The International Covenant on Civil and Political Rights. So when the US became a party in 1992, it attached reservations that had the effect of excluding any US obligations under the covenant that might add anything to already existing US law. So basically, again, it said the US say that those provisions don't apply to it. And then, of course, the other big one, the US they love promoting some of these instruments and documents without becoming parties themselves to, as we say, with the talks again here about the Rome Statute for the International Criminal Court. Again, the United Nations Convention on the Law of the Sea is an example. The US is not a party to UNCLOS, largely because of provisions on deep seabed mining to which reservations could not be made, because a lot of conventions prohibit reservations. This is actually what this paragraph is about. So the US, they wanted it seems a reservation on that provision, but they weren't because reservations were prohibited, then they just didn't sign up to the convention at all. No, another interesting. The US objected to the clause in Tobacco Control Convention prohibiting reservations. So again, that's another one they haven't signed up to. The Commission continues to clarify questions of treaty law that are not fully addressed in the Vienna Convention, for example, in the role of subsequent agreements and subsequent practice in relation to interpretation of treaties, i.e. to what extent later agreements or acts affect the meaning of treaty provisions and the provisional application of treaties, their effects before they enter into force. The Commission has also worked on matters falling outside the scope of the Vienna Convention, such as extended participation in general multilateral treaties concluded under the auspices of the League of Nations, the succession of states in respect of treaties and the effect of armed conflicts on treaties. In 1986, states concluded the Vienna Convention on the Law of Treaties between states and international organizations, or between international organizations based on a draft by the Commission. The UN continues to play a major role in international treaty making. The Secretary General acts as the custodian or depository of more than 600 multilateral treaties and advises member states on treaty practice. That's an important word. Again, just be familiar with the depository. You will hear that mentioned in different contexts, not just the UN, but there's, for all treaties, basically, there's a depository. He's the guy who basically looks after the treaty. I think in the other languages, like depositaire, el depositario. Through the treaty sections of the UN Office of Legal Affairs, the SG also publishes all treaties and international agreements that member states register with the UN under Article 102 of the UN Charter in the United Nations Treaty Series. So I guess that's like the official gazette. When a treaty is officially sort of made public, it's published in the UN United Nations Treaty Series. Chapter 12, Sources of International Law. Okay, so you have a quote there from the Statute of the International Court of Justice. International conventions or treaties are an important source of international law, but they're not the only one. International custom, unwritten yet binding rules flowing from practice, also govern international legal relations. While it's been the Commission's mission to codify much of international customary law into conventions, its statute also instructs it to consider ways and means for making the evidence of customary international law more readily available. The Commission took up this task immediately upon its establishment in 1949, recommending the preparation and distribution of a range of legal publications by the UN, many of which remain in production. The Commission returned to the topic in 2012 when it commenced its examination of the topic Identification of Customary International Law. Conventions and custom, together with general principles of law, are listed in Article 38, Para 1 of the Statute of the ICJ, which is often considered an authoritative list of sources of international law. The Commission added the topic General Principles of Law to its long-term programme of work in 2017. As to other possible sources of international law, in 2006, the Commission published guiding principles to clarify to what extent unilateral acts of states are binding under international law. Scholars continue to debate whether the output of the Commission itself can be considered as a subsidiary means for the determination of rules of law in the sense of Article 38, paragraph 1d of the Statute of the ICJ. As international law continues to expand, the ILC has considered how rules from different areas, for example, trade and environment, or armed conflict and human rights, can harmoniously interact in the international legal system. In 2011, it examined the resolution of norm conflicts in a study on fragmentation of international law, difficulties arising from the diversification and expansion of international law. Since 2016, the Commission is considering the hierarchical relations between norms of international law under its topic Peremptory Norms of General International Law, Jus Cogens. So again, here we have this mention again of this old friend Jus Cogens, Peremptory Norms of General International Law. Very important concept. Diplomatic and consular relations. From Mesopotamian emissaries to modern-day envoys, diplomatic and consular relations are some of the world's oldest forms of international interaction. For centuries, the practice of sending representatives abroad to negotiate political deals, encourage trade relations, or aid nationals in distress was governed by diplomatic and consular custom. First rules written appeared after the Napoleonic Wars to resolve conflicts about diplomatic rank at the Conference of Vienna. That's an important Congress, I believe, historically. However, states had not undertaken concerted efforts to codify the rules of diplomatic and consular practice until the International Law Commission took up the topics in the 1950s. Diplomats deal with the political interaction between states on matters such as trade or military cooperation. Consular officers connect nationals across borders in the fields of commerce, culture, and scientific exchange. Consulates also offer practical assistance by issuing passports, visas, and visiting imprisoned compatriots. Since all states send and receive diplomats and consular officers, all have an interest in clear rules and a means to reciprocate in the case of a violation. The 1961 Vienna Convention on Diplomatic Relations and the 1963 Vienna Convention on Consular Relations are thus among the ILC's most successful codification projects. The conventions govern the establishment and conclusion of diplomatic and consular relations, privileges and immunities diplomats and consular officers enjoy, and their rules of conduct when on mission. As per the convention, diplomats are not above local laws, though they are immune from their enforcement. In cases of grave violations, their country can waive that immunity, or the host country can declare the perpetrator persona non grata. Okay, so that's an important principle that you probably are familiar with when, like an ambassador or whatever is declared persona non grata and can be expelled from the country. Similarly, embassies are not technically foreign territory. This is interesting bit of general knowledge. Instead, diplomatic premises are inviolable, which means that the host state cannot enforce its laws there and must obtain explicit consent to enter the premises. I suppose this harks to the case of Julian Assange, right, who was holed up in the Ecuadorian embassy in London for many years, and the UK authorities weren't able to break into the embassy to get him out because, so as it says here, they're not technically foreign territory, but they're inviolable. So they're just not allowed to, under the rules of the game, they're just not allowed to go in there. And I think they got him out in the end. Well, I guess they must have come to some agreement with I think there was a new government in Ecuador who were basically more easily persuaded to get Assange out the premises, and so they basically handed him over, and the UK police arrested him. The Commission also dealt with specific questions of diplomatic practice, resulting in conventions on the status of special missions and the prevention and punishment of crimes against diplomatic agents and other internationally protected persons. The Commission also proposed rules on the status of the diplomatic courier and the diplomatic bag not accompanied by the diplomatic courier. In addition, the Commission prepared draft articles that led to the adoption of the Convention on the Representation of States in their relations with international organizations of universal character. Okay, so this is more general stuff at the moment. I'll speed through this a bit more. Set on the peaceful shores of Lake Como, so this is jurisdiction and immunity. This is important stuff here. Set in the peaceful shores of Lake Como in the Italian Alps, Villa Vigone, a German-Italian cultural centre, seems an unlikely subject of international legal battles. Yet in 2012, it was at the centre of a legal dispute over the doctrine of state immunity when Italy sought to seize it as a reparation, again there's that word, reparation, restitution, remedy, redress, for alleged international crimes committed by Germany in the course of the Second World War. State immunity is the immunity that a state enjoys in the courts of another state. It flows from the principle of sovereign equality, which holds that from the perspective of international law, all states are on an equal footing. As a consequence, no state or sovereign should sit in judgment over another sovereign. Par in parem non habet imperium. Sovereign equality is a foundational principle of the UN embodied in Article 2, Paragraph 1 of its Charter. So again, that's a very important idea, okay? That all states, large and small, they are all equal, okay? And this is something that's stressed repeatedly, usually by the smaller states, to say that, oh, you can't just boss us around, you know? Under the Charter, we're all equal. And indeed, Article 2, Paragraph 1 does say the organization is based on the principle of the sovereign equality of all its members. Well, anyway, that's the theory, right? Some immunity, state immunity used to be absolute. National courts couldn't rule on any aspect of a foreign state's dealings. Yet as states' commercial activity increased, national tribunals began to distinguish between official public acts of the state, acta iure imperii, and acts relating to business transactions, acta iure gestionis. The former remain covered by state immunity, while the latter no longer benefit from its protection. To capture this development, the ILC presented draft articles on jurisdictional immunities of states and their property to the GA in 1991. The Assembly adopted the UN Convention on Jurisdictional Immunities of States and their Property in 2004. One of the most controversial questions remains the extent to which states and their officials can enjoy immunity in relation to international crimes. This was at issue in the case between Germany and Italy that involved Villa Vigone. In 2012, the ICJ, quoting the 2004 UN Convention, ruled that the villa was protected. While the court resolved that case, the law of state immunity continues to develop in the practice of states. The Commission has also continued its engagement with the field and is currently considering the immunity of state officials from foreign criminal jurisdictions, an aspect of the law of state immunity. So a controversial topic sometimes, this idea of diplomatic immunity, right? That diplomats working in a foreign country aren't subject to the same laws. Okay, getting to the end here, close now. Nationality and statelessness. Passports are perhaps the most tangible symbols of nationality and the benefits it brings. One nationality offers protection abroad and often grants access to education, employment, housing, and healthcare. UNHCR estimates, however, that more than 10 million people cannot obtain a passport because they're not recognized as a national by any state. They are stateless. Безгражданство, big thing for the Russians, okay? Stateless persons often cannot travel to work and lack access to social services. International efforts to reduce statelessness date back to the end of the First World War. During the interbellum, the League of Nations issued so-called Nansen passports to stateless refugees, which allowed them to travel and protected them from deportation. I thought that was an interesting bit of general knowledge. I didn't know about that. Nansen passports. After the Second World War, when thousands of people lost their nationality due to domestic policies and the redrawing of international boundaries, the United Nations took up the issue. The UN Economic and Social Council, ECOSOC, asked the ILC in 1950 to examine legal mechanisms to eliminate or reduce statelessness. Given the sensitive nature of the topic, the ILC prepared 2 draft conventions, one with a strict aim of eliminating future statelessness, another striving more modestly for its future reduction. Together with a report on present statelessness, the Commission submitted these texts to the General Assembly in 1954. A diplomatic conference convened by the General Assembly in Geneva and New York adopted the Convention on the Reduction of Statelessness in 1961. It entered into force in 1975. The 1961 Convention not only encourages states to prevent statelessness, but also imposes positive obligations on states to grant nationality in certain circumstances. Its objective to guarantee access to nationality for all is reflected in many international and regional human rights instruments. The ILC continues to progressively develop international law in this field. In 2006, it recommended that states extend diplomatic protection to stateless persons who are lawfully and habitually resident in their territory. Its articles on the expulsion of aliens, adopted in 2014, acknowledge the right of states to expel aliens from their territory, but offer substantive and procedural protections against arbitrary expulsion and the deprivation of nationality. Now, why is this a big thing for the Russians? Well, the reason is basically upon the collapse of the Soviet Union, you suddenly overnight had millions of Russians who suddenly found themselves living outside the borders of what had previously been Russia, the Soviet Union, particularly in the Baltic republics, Lithuania, Latvia, Estonia, in places like Kazakhstan as well, and many of them became stateless. Now, I don't know the exact ins and outs of it. I don't know if they didn't want the nationality of the new country, be it Lithuania or Estonia, whatever. Many of them, as I said, had no passport at all. And this is a thing, I guess the Russians have used this as leverage quite a lot. They say that these countries aren't delivering on their obligations to provide these people with citizenship as they should be doing, as per the agreements they've signed up to. So it's they'll often talk about it. For example, I seem to remember in the General Assembly, in the third committee, that'll be one of the things they'll use to criticize the Baltic republics in particular. They sort of save that kind of criticism for them. So yeah, it's definitely statelessness is definitely a thing, okay, that you should be familiar with. Okay, the succession of states. I'll let you read that yourself. There's nothing, I mean, it's basically what, when you have a bigger country that collapses, like the Soviet Union, like the former Yugoslavia, and who is the natural successor of that state subsequently, who bears the obligations, who inherits the obligations of the old state. Okay, specialized fields of international law. In the last 70 years, international law has diversified and expanded considerably. The ILC continues to be at the forefront of the progressive development of international law and its codification, once again, by selecting innovative and highly technical topics of international law on which it often collaborates with other agencies and organizations. International water law. In 1997, the ICJ rendered judgment in the Gabčíkovo-Nagymorsk project case concerning a planned hydroelectric dam in the River Danube on the border between Hungary and Slovakia. It ordered the two states to share the natural resources, the Danube, in an equitable, reasonable manner. In support, the court cited the Convention on the Law of Non-Navigational Uses of International Watercourses, which the GA had adopted only a few months earlier. The convention had been in the making since 1970, when the International Law Commission took up the topic of the law of non-navigational uses of international watercourses at the suggestion of the General Assembly. Apart from provisions on the protection, preservation, and management of international watercourses, the convention enshrines the fundamental principle of international water law, namely equitable and reasonable utilization, the obligation not to cause significant harm, and the obligation to cooperate and notify other states of planned measures. Yeah, I think I've noticed that this concept is becoming increasingly prominent in a lot of meetings. This, especially water shared resources, These principles are also central to the Commission's draft articles on transboundary aquifers concerning the use by states of shared confined groundwater resources. The articles, which the Commission developed in close collaboration with hydrological experts, grew out of its work on international water courses and other shared natural resources. Together, the Convention and the articles mark a significant step in the progressive development of international water law. The Commission's work continues to inspire bilateral and regional arrangements for the management of shared natural water resources. So yeah, this is definitely a big thing, especially like in Africa, for example. You have these commissions that have been set up between countries who lie adjacent to a given body of water. You have these commissions like the Lake Niger Commission, the Lake Chad Commission. So yeah, they have these commissions that basically govern the sharing of the resources provided by bodies of water like the Niger River, the Lake Chad, the Zambezi River, and they're becoming increasingly important players on the scene, and it's an important issue. It's all to do with the building of dams, which countries benefit from dams, and ensuring that, as I say, that the benefits of such projects are fairly distributed, and it can be the cause of disputes and conflicts. I know I think it's Ethiopia and Egypt, there is a big dispute over, I think it's called the Al Nahda Dam, if perhaps you've heard of it. And I guess this would fall under this whole subject of the equitable, reasonable utilization of these watercourses. It's an interesting little diagram here as well, just to show you some of these words. When I first started the UN, I was confused me, like, what was the water table? La nappe. I know, like in French, about la nappe, the water table. Okay, then disaster relief. Okay, so this tells you this is an important project. This refers to the earthquake back in the Indian Ocean in 2004. Earthquake off the coast of Sumatra set off a tsunami in the Indian Ocean, causing devastation from Indonesia to the Horn of Africa. The disaster prompted a worldwide humanitarian response by states, organizations, and individuals. It spurred the ILC to consider the international law of disaster relief assistance and risk reduction. As a result, in 2016, it adopted the draft articles on the protection of persons in the event of disasters. The articles strike a delicate balance between state sovereignty and the obligation to provide protection and relief. They stress the primary role of the affected state in risk reduction and disaster response, but also instruct it to seek assistance from other states, the UN, and other assisting actors, such as components of the Red Cross and Red Crescent, if the extent of a disaster manifestly exceeds the national response capacity. While not obliged to accept, states may not arbitrarily withhold consent to external assistance. This is all about disaster relief reduction. You'll hear in that context the Sendai Framework for Action, or rather the Sendai Framework for Disaster Risk Reduction, which basically sets out measures for reacting to future natural disasters. I think it was pretty symbolic that it was held in Japan, in Sendai, probably related to the tsunami in Japan. When was that? 2012 or something, 2010, when you had the Fukushima power plant go up. So that's an important document just to be familiar with. Okay, specialized fields of international law 2. Okay, the Canadian city of Treaillis hosts the largest zinc and lead smelter in the world. When in the 1930s its sulfur dioxide emissions ravaged crops and livestock 8 miles across the border with the US, the two countries established an arbitral tribunal to answer the question who should pay for transboundary damage caused by hazardous activity that is lawful under international law. Again, this is a very important topic, because 40 years later, the International Law Commission faced the same issue when it took up the topic of international liability for injurious consequences arising out of acts not prohibited by international law. Unlike the topic of state responsibility, which deals with responsibility for international wrongs, this question concerns the responsibility for risks associated with lawful but hazardous activities, for example, industry, mining, and energy production. The Commission eventually divided the topic into two parts. Its articles on the prevention of transboundary harm from hazardous activities reflect the principle first formulated by the Trail Smelter Tribunal that states should take all appropriate measures to prevent transboundary harm, including by conducting environmental impact assessments and notifying neighbouring states of potential risks. This idea of the environmental impact assessment, the EIA, is a concept, an instrument that is mentioned a lot, and the need for prior notification. Okay, the principles on the allocation of loss in the case of transboundary harm arising out of hazardous activities adopted with the Commission in 2006 confirm the principle, also central to international environment law since the trial smelter case, that the polluter must pay for any transboundary damage that its activities may cause. So that's again, I think, a concept that is referenced frequently, polluter pays principle. So environmental law, the polluter pays principle is enacted to make the party responsible for producing pollution, responsible for paying for the damage done to the natural environment. The Commission's current programme of work includes 2 items relating to the environment. Since 2013, it has been considering the topic protection of the environment in relation to armed conflict. In the same year, it commenced work on the topic prevention of the atmosphere, on which it has since held a series of dialogues with scientists. So I've done meetings with respect to both of these topics, actually. I know there's talk of invoking the situation in Ukraine into the protection of the environment in relation to armed conflict, that the idea that Russia may have to sort of pay some, compensation for damage done to the environment. I don't know how far it will get. I'm just saying that it was talked about at one of the meetings I attended. Non-discrimination in international trade and investment. Non-discrimination is central to a fair, balanced system of international trade and investment. Translated into legal terms, the principle of non-discrimination is embodied by the most favored nation clause. I hear that mentioned a lot. Most favored, granting nations, most favored nation status. The clause, which can be found in many trade and investment treaties, obliges a state to extend to other states treatment that is no less favourable than what it accords to third states. The International Law Commission, which initially considered the topic in the context of the law of treaties, worked on the most favoured nation clause twice. Between 67 and 78, it developed a set of draft articles that focused on its application in trade treaties. Following new developments, a study group examined the role of the most favoured nation clause in international investment law from 2008 to 2015, resulting in a report and summary conclusions. And I think this is pretty much the final page. Other bodies. Well, the International Law Commission is the designated organ at the United Nations to further the progressive development and codification of international law. And there we have it again, our favourite phrase. Other bodies within and outside the UN also contribute to international law's advancement, including the General Assembly, that's the most obvious one, through its 6th committee, considers the work of the ILC and debates other legal questions. It also develops new instruments through ad hoc or special committees and through diplomatic conferences. If you ever get assigned to the 6th committee, that can be very difficult. That can be very challenging. A lot of the same legal stuff that you hear at the ILC. Often you get a lot of Latin American delegations that are very active. I find the Latin American delegations are very focused very much on the legal nuts and bolts of treaties and international law. So there tends to be a lot of very tough Spanish in those meetings. ECOSOC, the Economic and Social Council, as one of the principal organs of the UN, the ECOSOC has played and continues to perform an important role in the development of international law in its field of interest, in particular the areas of human rights and status of women. UNCITRAL, based in Vienna, Austria, the United Nations Commission on international trade law, which is a subsidiary organ of the General Assembly, like the ILC, contributes to the modernization and harmonization of national commercial legislation by providing conventions, model laws, and technical assistance in various areas of business, from electronic commerce to investor-state dispute settlement reform. So, and they also met a few times when I was working in New York as well, UNCITRAL. In a meeting, and they talk about UNCITRAL, they often refer to these model laws, loi type, in French, I guess les types, and even in Russian it's typavoy zakon. That's basically those model laws are essentially their building blocks, and everything revolves around them, changing them, updating them, amending them. And we have the regional organizations here they mention, private international law. Okay, I'll let you read that yourselves. And that's pretty much it for that exhibition. There you go. Give you some ideas for further reading if you want here to enhance your knowledge of the ILC. But that basically, I think we've covered the main elements there. So hopefully that may help you, giving you some knowledge here of the very foundation stones of the UN, at least from a legal perspective. Like I say, there's a lot of these ideas do permeate into so much of the other more mainstream meetings, if you like, council, the Security Council, General Assembly, and it really does. It helps to know really of a bit about the inner workings of the beast. Okay, well, if you have learnt something from this episode, you'll have to forgive me. I've been talking a bit more quietly the second half of this because my kids have gone to bed, so I have to keep my voice down a bit. If you've enjoyed it, please do click the like button, share, subscribe. I will leave a link with this file with the pictures from that exhibition so that you can peruse it at your own leisure. All I can say is leave comments if there's something new that you found particularly interesting about this exhibition. Please do tell me in the comments. Keep on following me on LinkedIn, on YouTube. And with that, it's time for me to go to bed now, I think. I've got to work tomorrow. So all that remains to be said is that episode 132 of the Interpretation Station stands adjourned.